Hey, welcome back to the All Pro Team podcast. We're glad you've joined us today. Today we have a guest that's returning to this month's podcast, Andrew Lovvorn from Tisinger Vance, attorneys here in town. And one of the things you may or may not know about Andrew, not only is he a great closing attorney, but he's great with wills and trust and stuff like that. So, Andrew, I would love for you to let's inform people a little bit about the need for wills, sure. and then let's talk a little bit about trusts and some protections that people can do.
Sure, absolutely. No, thank you for having me again. As you mentioned, so my practice consists of two things. So I do our help with real estate closings, and then I also lead our estate planning and probate department. So as a part of estate planning, so a will, trust, power of attorney, all that is what consists of estate planning. So really, when I meet with people, and we're meeting with probably anywhere from, I'd say on average maybe 5 families a day to go over the estate planning process.
Well, that's a lot more than I would have thought.
Yeah, so between me and Caitlin Harris is in our office, and then also we got a new attorney named Clint Kelly who'll be starting in early September. So the three of us are handling all of that, and then also the real estate as well, along with Phil. But really, the estate planning process, I tell everybody, it's a 2-step process when they come into our office. So we have an initial meeting, which I call a fact-finding mission, where we go over all their family information, their assets, and I lead with those two things, and I always tell them the asset conversation is protected by the attorney-client privilege. So I don't go sharing their business with anybody, but that is critical information to have to figure out the appropriate plan for them, whether that be a will, a trust. Everybody needs powers of attorney. I'll talk about those, but really, in the estate planning world, there are 2 main documents that you'll have, either a will or a trust, and to highlight those differences, okay? So a lot of, in Georgia, I would say by default, the more people have wills than trust, and really the way I look at it is, unless you have a compelling reason for a trust, I do a will.
Okay.
So, for instance, I'm married with 2 young children. You are married with adult children, mm-hmm. All right? So I have a will that has what's called a children's trust in there. So if I die, everything goes to my wife. If she doesn't survive me, then it goes into trust for the kids until they reach the age of, I chose 25 at that time to make sure that they're mature enough. Whereas you with adult children, your will would look differently than mine, right, because you have adult kids, so you don't need that trust language in there, right. Okay? So everybody's wills and trust look differently based upon where they are in life. Do you have minor children? Do you have adult children? Do you have somebody with disabilities? Do you just have somebody who is a spendthrift? Yeah. All families are different, and not saying that in a good way or bad way, but it's just what's good for one person won't be good for the next. So,
while we're talking about wills, can you speak to a little bit about when people don't have one? Because in Georgia,
sure,
you take title, the joint right of tenancy, and so it's called the poor man's will. So
right,
if one spouse dies or one person on title dies, it automatically reverts to the other spouse. I know there's a lot of headaches with some of that and a lot of catches.
Right. In the real estate perspective, that is where we run into an issue a lot when Andrew and Crystal are on title, and then when we do the title exam, the real estate agent thinks, okay, well, Andrew's now deceased, Crystal owns it all. Well, if the deed doesn't have that joint tenancy language, then technically Crystal owns 50%, Andrew's estate owns 50%. Mm. So that has to go through the probate process. So if Andrew in that situation, talking in third person seems weird, but Andrew in that situation has a will, then it can go through the probate process pretty quickly. If it don't have a will, then you have to go through what's called the administration process, which is Georgia has what are called intestacy laws. So that if you don't have a will saying here's what everybody is getting, those intestacy laws dictate that. So again, I'm married with 2 children. If I did not have a will, a lot of people think, oh, it automatically goes to the spouse. No, it doesn't. So if I died without a will, Crystal gets a third, and each of my girls get a third.
Wow.
And, if that was the issue we found that out as part of the closing process, we've got an issue there because now we've got 2 minors involved. It's going to take, if you don't have a will, the probate process is typically going to take about 2 months in order to get, because there's a notice that has to run in the newspaper for a month, and there's 10 days after that. So typically about 2 months. So not having a will can really slow the closing process down if somebody has passed away in the back chain.
It makes life easier on the surviving spouse,
sure.
Even though that, and it's not a super big expense, I wouldn't think, to put together a simple will that says everything, if something happens to me, everything goes to Tina, and something happens to Tina, everything goes to me, or whatever. So I would think that'd be good. I just know that we've run into that a few times where the deceased spouse is still on title, and we're like, oh wow, we've got a mess on our hands to get through. But you guys have been great about helping us through that kind of stuff. I
would estimate I probably get 3 or 4 probate files a month just based off real estate, where we're doing a closing and a situation rolls up where, hey, Mr. Smith passed away, he was still on title, we need to probate that. And the family just didn't realize that it didn't automatically go to the spouse, because in joint ownership you have a joint tenants with a survivorship deed, but the deed explicitly has to state that it is joint tenants with survivorship. If it doesn't, then it's what's called tenants in common, and that is when it has to go through the probate process. So a lot of people think husband and wives, when one passes away, the survivor automatically thinks, oh, well, I now own it, and that's not always the case.
Right.
So that's where we run into that a lot.
Thanks for going down that little rabbit trail, because I know that people need to know, the death rate on Earth is 100%, so it's wise to prepare for that. It sounds kind of morbid kind of conversation, but talk a little bit about trust, if you don't mind now,
sure.
in a situation where a trust makes sense.
Sure. So hit on one thing real quick. You mentioned like the cost and so forth. So look, I'll be the first to say this is a very, very self-serving comment, because me doing the work for you means fees for us. Right. But still, as you mentioned, the cost associated with estate planning, it does depends on what you need. A will is going to be cheaper, where a trust is going to be more expensive. Wills are typically, everything's less than $1,000. Trusts are typically somewhere between $1,000 and $2,000. Again, it totally just depends on what the family needs. So if you say, hey, I want a will, that's very simple. A trust is more expensive because there is additional work involved. So the analogy I use for everybody that comes into the office is a trust is just an empty fruit basket. So I prepare the Dwayne Hicks Trust. That is just a piece of paper that, then again, the analogy being the fruit basket, and then we have to start putting the fruit in there, the fruit being your assets, okay? Yeah. Because if you're going to have a trust, the idea is you start operating and putting stuff into the trust. Okay. So if Dwayne wants to put his house in there, we got to do a deed, and there's just additional work involved. So that's why trusts are more expensive, if I can get that out. But situations where a trust can be more beneficial than a will are if you just absolutely want to avoid the probate process. Okay. So wills go through the probate process. They're public record. Everybody can see what it says. I don't care that everybody sees my wife gets everything and then my kids get it if she doesn't. But if there's something people don't want people to know, then trust is a good one.
Business owners and people that have large assets or large amount of assets is typically the people that you trust.
Yeah, and it's not even that wills say I've got $5 million and that's what I'm given, but a lot of times people just, a variety of reasons why people don't want, to go through the probate process.
Is there also some, like for the estate, is there some benefits from taxation, or is that kind of
not Not really.
I know that you're not a CPA or whatever, so I didn't want to...
Trust you can do some advanced planning with trust that's probably beyond the scope of this conversation today that could help. But overall, will versus a revocable trust, not typically any huge tax difference. But also, if you own property in multiple states, so if I passed away owning a house in Carrollton, a lake house at Wedowee, and a condo in Panama City, okay, then I have a will, I have to probate it in all three
Oh, wow.
of those states.
Okay.
So a trust, whereas if the Andrew Lovvorn Trust is prepared and owns all three of those houses, then it's automatic. You don't have to, it makes it very simple.
Okay.
So a lot of times people that own property in multiple states, a trust can be beneficial. I handled a lady's estate years ago that luckily we had done planning. She owned a house in Georgia, Florida, Alabama, and Washington State. So we did a trust. Instead of having to probate it in all four of those states, I was able to just take the trust and run with it, and it made it nice and neat. So while it was a little more expensive on the front end to set up, it saved her estate thousands upon thousands of dollars. Absolutely.
I mean, and that's I guess that's the number one takeaway.
Yes.
If you do this ahead of time, it's a gift you give to the people who remain behind.
It is absolutely, so let's say you pay our office $700-800 for wills, powers of attorney, all that. The cost I get it, like that's a sunk cost for you because you're not benefiting from it. You're going to be deceased. But the cost and headache that it saves your family on the back end, it pays off in spades. Like it there's been so many people, and I bet I've done estate planning for probably at least 10,000 families by now. And the people that do the planning beforehand, it makes the back end process so much easier.
They're already grieving the loss.
That's exactly right.
They're already going through funeral expenses.
Right.
And just that whole process. And then on top of that, they got to flip their business hat on and try to deal with the financial struggles of whatever, probate or whatever. So it's, man, if you get nothing away from today, at least take that. Maybe that financial planning, wills, and trust, or whatever Andrew and his team were to advise you to do, is a gift you give people who are left behind when you pass. So, Andrew, is there anything else you want to cover today? You've really been running around the room on this. Is there anything
so a couple of things. So a complete estate plan is a will or trust, and then financial power of attorney and healthcare power of attorney. Okay? So we, anytime we do any estate planning, whether it be a will or a trust, we also do those powers of attorney. The financial, so while you're living, if you get in a position where you can't make your own financial decisions, that somebody is appointed to make those for you. And then healthcare, I call it the healthcare power of attorney. The technical name is an advance directive, but other people call it living wills, DNR. There's so many variations but it's the same document. So you're saying in the healthcare, not only are you saying, okay, here's who can make my decisions, but you're also in the living will portion of it, you're also going ahead and laying out your desires regarding life support and all that. Okay. So it makes, I cannot tell you how many families have come back to me because, unfortunately, a lot of my clientele are no longer with us.
Right.
A lot of the families will come back and say, oh, it was such peace of mind that mom or dad went ahead and did their living will and chose not to get life support, so that it really changed the narrative from me having to, quote unquote, pull the plug on them to me just doing what mom or dad wanted. And the peace of mind that it presented to them was substantial. So that is,
the power of attorney is any kind of, an accident can, render us incapacitated. And so if that piece is behind the scenes, it's just pretty easy.
And the biggest thing we see, and so many people are facing it these days, is Alzheimer's or dementia. Unfortunately, I feel like it being on such a incredible rise, there are more and more and more families dealing with that. So having that power of attorney in place really allows the family to make decisions for those people who are suffering from the mental infirmities.
And they're making decisions based on what they were thinking when they were all clear too, with some of those things. Yeah. Well, thank you again for being here today, man. This is pretty insightful. And I think, when Tina and I went through this process, I watched some dear friends that didn't have this in place. Yeah. And what a quagmire it can be, especially if there's multiple assets or businesses or properties or whatever. It's just a lot for the surviving spouse or family to deal with. And so I think I told Tina, I said, if something happens to me, there's about 3 people you can call, and everything will be good. You can just, I know she'll be maybe, hopefully she'll be upset that I'm gone, but whatever. But she will not have to stress about business ownership or assets and stuff
with,
like that.
With proper planning, my desire is that for when those people's time do come, that the family, like you said, while they're going through the grieving process, they're not having to put a puzzle together. Instead, they're just taking, I always recommend people make a folder that says, okay, at my death, here's a copy of all my documents, here's bank statements, here's insurance statements, call Andrew to handle the probate, call Dwayne to handle the real estate, call Jason about the insurance, and so forth. So that way,
that's really smart. That's another piece to it to make
you're not putting that puzzle together. You're just picking up and running with it. So
again, I hope this has been informational to you. The All Pro team is here to help serve, and Andrew is a great friend, and he's one that we recommend a lot for this type of planning and preparation. So by all means, feel free to reach out to him. If you'd like to connect to him, we can also help you with that, connect you. But thanks for being here again, Andrew, and thank you for tuning in.
Appreciate it. Thank you.